Good morning, everyone. Welcome to another forms class. Today, I've got a very exciting one for you. Lead-based paint pamphlets and 22J lead-based paint addendums. We're going to jump right in like we normally do. Let me share my screen. Right. Let me hide the windows. All right, so lead-based paint disclosure addendum. Use. This form contains disclosures and certifications that are required in purchase and sale transactions involving residential property built prior to 1978. Let's pause right here because so many brokers get this wrong and they still see it. In fact, I was talking to someone earlier in the week and they literally like, oh my goodness, this person listed this house and it's built in 1979. And they've got their sellers filling out lead-based paint addendums, and they've got a 22J in the supplements.
I had the one.
You did too.
2002.
Oh yeah,
She had to fill
2002.
it out.
So I don't know. It's one of these things that, in your career, you're going to be dealing with this a lot. Any property that is built in 1977 and under, you have to have 22J in it. And you have to have the pamphlet protect your family from lead in your home. This has to be provided to the client. So that is a United States Environmental Protection Agency pamphlet that has to be provided, and you got to have proof that you've given it. As long as you use transaction desk, right? You've got no issues at all about, making sure that that you have the proof. You don't need to actually have initials on this pamphlet at all. In fact, there's no spot in the pamphlet whatsoever for initials. But if you want to, you can. It's one of those things you don't have to. In the 22J itself, there is, in the last updates that they've done in, I think it was in 2020 or 2019, somewhere in there, that they did add in the section for buyer's initials. So now they've made it to where, the buyer can initial here, and it's an acknowledgement that they've received these items. So we're gonna break this down about what it is and where that is.
Oh,
You have a question?
No, I just said, oh, nice. I didn't know it had that now.
Yeah.
I noticed that the map actually has it in there now too. Before it didn't, if you hit the map for the signatures,
Mhm.
which is kind of nice.
Yeah, it'll just place them right there. So we're gonna talk about that, of course, too. But first things first, like we just read, do not have, sellers should not be filling out a 22J if the home was built in 1978 or above. So 77 and under, you got to do it. What about a house that was built in 1929, but then it was totally stripped down to the studs and remodeled, rebuilt, added on to, and it has an effective year built of 2015 now in the county?
I would say yes.
What do you guys think? Do you need it? County says it's effectively built in 2015 now. Why would you need it? Huh?
It goes off the actual.
Yeah, it goes off of whenever it was built. So you can't take the effective year built and make that a replacement for when it was actually built. You could get yourself in trouble and not providing, the pamphlet and everything. You still got to do it. So just always base that off of the original year built. Don't get yourself in trouble. So
That example you said, if it was like built in 2000 and they put the forms in there and you're the buyer's broker, what do you, and it's in the supplements, do you just not put it in your offer?
Absolutely, correct.
Okay.
Yeah. If it is in if all of a sudden a listing broker had their client fill this out and the house is built actually, you know, in 1978 or above, don't even use it. Don't have your buyer sign it. Don't send the pamphlet. Just, I mean, you don't want to be rude and tell the listed broker like, you're wrong. Hey, idiot, why do you have this in there? You know what I'm saying? Some people like think, oh, I'm protecting the clients, you know, I'm putting this in there. It's completely unnecessary. You like the rules to the form itself tells you that it's required only in those years. I know there's definitely confusion if you had a broker, and we've unfortunately seen stuff like this. They say that, oh, the house was built in 2003 or 1995 or something like that. And then come to find out, the inspector's got into the crawl space and he's like, oh, wow, there's like old oil lines in here. So this house used to run on oil. And also there's knob and tube wiring. So, you know, like, wait a minute, that's impossible. You know, if the house was built really in 95, you're not installing those items, right? That doesn't make sense. And so at that point, we had to question like, hey, you said, you know, you put the year built, so then we checked into the county records. It's like, yeah, no, yeah, it was actually built early in the 50s. So then it would be required. So it's like these things you just got to really check, you know, make sure. You just know that no matter what, if you are representing a client, you know, a buyer, and if it is built in 1977 or under, then it will require the form. And we've also run into issues where the listing broker listed it and they never had the client fill in a 22J at all. So what do you do in that situation? What would you do? Huh?
Call them.
What are you gonna say? You're gonna call them? Oh, they don't answer. They don't pick up. Offers are due in 3 hours. Huh? Yeah, you could fill it. You might as well know it's gonna be needed in the transaction. So you gotta include it. You gotta give the pamphlet to the client. But how do you know what the disclosures will be for the client? How do you know what the seller's actual disclosures are? So right here. Do you guys know where else these exact same disclosures are? That's right, Jason said it. The Form 17 also has the exact same disclosures for lead-based paint. They're exactly the same thing, right? So if you go to the Form 17 and it's there and it is filled in, you can go ahead and just mark these. Mark it exactly what the seller did. Because if you're dealing with someone who's not properly having their clients fill in the actual lead-based paint pamphlet, or excuse me, the disclosure, you know, in the 22J for the lead-based paint addendum, like, as long as you know it says it's there, it's okay to mark it here. This isn't a Form 17. This isn't a seller disclosure statement. So I'm not telling you to go ahead and fill in, you know, the seller's disclosure statement, but you can go ahead and just do this.
So one step further, you go to a listing, you're the buyer's broker, and it
Yep.
just has the exhibit A in there,
Yeah,
and you see on there that it was built in 1960. So you would just do that and leave that empty, I guess?
yeah. Then you can go ahead and just sign it. Mark, you know, go ahead and leave these blank. Yeah, if you've got no Form 17 on, you can't tell, you know, if the disclosure was not made, you can't fill this in. You'll just have to send it and wait for the counter, which is unfortunate. It's very lazy, you know, for a listing broker not to have this filled in by their seller and just completely marked, signed, initialed, and then even the listing broker signed, because this is one of the forms that you will be signing also. So all the time too, we see it gets missed. For some reason, I don't know why, but some of the brokers themselves miss this. If you're the listing broker, then you should have this already pre-done, filled in. You have already signed it. Sellers made their disclosures. You can even if you want, leave this, you know, blank, it's okay to where you get the offer, then the seller can sign it, or just have the seller initial it too, you know, on the bottom, which I usually do that for my sellers. But it's gotta be done. No matter what, you know that the law is there that, you know, to protect consumers when it comes to lead, you know, base paint. So it's, you might as well just get it done from the get-go. If it's not there, put it in there. If you can't get the disclosure, then just do it that other way. All right, let's continue.
What if you get, you're the representing the seller?
Yep.
And you get an offer that comes in and they didn't have it in there. Do you want to sign it around and then maybe get it after the fact?
What do you guys think? What would you do in that situation? Would you sign it around, go ahead and sign their offer around, get mutual of what they've sent you?
What was the question?
If a buyer broker sent you the offer, you had it in the supplements, they just didn't use it. Now, did they write it in on the addenda line or not written in on the addenda line?
Say it's not even in there.
Not even in there, not on the addenda line. Would you allow your seller to sign that around to get mutual? What do you think?
No.
No? Why not?
They're gonna be signing it, why don't you have them fill that out too?
I'd call them.
It sounds easy, but why would you not do it, John?
Because of, it's not in there, and I don't think it would make it's not valid if that's not in there.
Well, it could be valid, it could be still a binding contract. But I want you guys to think about something. And this goes,
Lawsuits.
well, this goes for anything. You could definitely get your seller to sign it. Can you force the buyer to sign something after you have mutual? Can the buyer say, I'm not signing that? This is something you got to think about whenever you're dealing with contracts. Remember that the other party could choose not to sign something. It's just like you're in a transaction and things are a little bumpy and you need an extension from lending or something just for one more day. One more day, and we're gonna have docs are gonna be there, they're gonna sign everything tomorrow, or release record tomorrow. We just need 1 day extension. Does the seller have to sign that extension? No. They could sell it to someone else after that point. You cannot force another party to sign something else. So in the event you're in the situation like Jason gave us for that example, I would not get mutual in this situation because this is a federal form that has to be in the agreement. If you don't have it, you get in that transaction, and all of a sudden you're in the transaction. And the buyer's like, nah, yeah, sure, we'll sign that later. We'll do that later. Yeah, we'll do it. And you're like, bro, we need that form. Come on. Why aren't you signing it? I don't know. They just don't want to now. You just don't get in that situation where now you're in this deal and you've got this federal form that's got to be in there and the disclosures have to be in there. And you got proof in the acknowledgement now too for the pamphlet's been received by the buyer. Like you don't go down that path. You might as well bite the bullet up front and go, hey, how come you didn't pull the form out of the supplements? You know, it was right there for you. Like, we got to have this. Like, we would have signed off on your offer as is if you would have had it. So now we have to counter with this. It's one of those things like you're gonna have to do it. In this case, do it. You're gonna have to like tell them and like, we got to counter. There's a lot of times I will tell you guys like, oh yeah, like Eric, they missed this. They didn't do this. Like, okay, Kim, you know, is this a federal thing? We gotta make sure that's in the deal. No, it's not a big deal. Get mutual. Worry about those things later. And if it never, you know, if it doesn't happen, then it doesn't happen. And you're not in the situation where, oh, great, I just put my client in jeopardy for a federal issue. You know, whenever it comes to any item like that, that's definitely a higher level of danger, you know, for the client that we don't want to put them in. All right, so the purpose of the disclosure requirements is to advise potential buyers of the health hazards of lead-based paint, the use of which was banned in 1978. So they banned it in 1978. Were contractors still using that same paint after 1978?
Oh, yeah.
Probably.
What? No, it's banned though.
They run out of material.
What would they, they run out of material?
Ran out.
Are you telling me that people don't follow the rules?
Oh, yeah.
What? Serious? See, you know what? There was a sighting, LP sighting, right? Louisiana Pacific sighting. That stuff, it was banned. There was like class action lawsuits. They sued the companies that, you know, they went bankrupt, all gone. And all of a sudden they had all of this material left. What do you think happened to that material? Did they destroy it all? No way. Some builder's like, are you telling me I could site this whole house for 10% of what I used to, you know, for my total cost? Like, are you kidding? I'll definitely use this material. The same thing was going on with the paint. I mean, unfortunately, you know, contractor, you know, they found, oh, it looks good. Can you see the paint or the lead, you know, in the paint with your eyes? No. It just, that stuff was happening. So that's something that you can tell your clients, like, you know, no matter what, there is no guarantee. Yeah, it was banned and it was recalled and it was a really bad health environment to especially children. That is what the one where it was definitely where it was the most dangerous. Why is it most dangerous to children?
They put stuff in their mouth.
Yeah,
Stunts their growth.
yeah. Kids like chew on the walls, chewing on, you know, like I mean, that's what happens. It was just definitely a bad thing. So, all right. Give buyers an opportunity to inspect the property for lead-based paint hazards. These regulations exist to protect children from lead poisoning, which has been called the #1 environmental threat to the health of children in the United States. It was pretty bad. Brokers are responsible for ensuring compliance. Any brokers involved in the transaction are responsible for ensuring that sellers are informed of these disclosure requirements and that sellers comply with the requirements. Exemptions. The regulations apply to so-called target housing, which consists of most housing built before 1978, except for housing for the elderly, housing for persons with disabilities, unless children under 6 will live in it, and dwellings with no bedrooms, such as in a studio apartments or individual rooms in a home. The regulations also do not apply to properties sold at foreclosure sales. If you are in doubt as to whether the regulations apply, then seek legal advice. So now if you don't know, you're not sure, you really can't say. They're telling you that you gotta tell the clients to seek legal advice. All right.
I had a client that was an estate sale and they're like, well, we don't have to disclose anything. And I was like, well, that's just for the Form 17. I go, the lead-based paint still needs to be filled out, right?
What do you guys think? Estate sales are exempt from providing a seller disclosure statement. That is one of the main exemptions in the state of Washington. What type of a disclosure is lead-based paint, though? Is that a Washington state disclosure? It's a federal disclosure. Do you think that applies then?
Yeah.
You think that they're exempt still?
Oh, no,
Need it.
you're tricking me.
Yeah, tricking you. Yeah, it is. They're not exempt from this one. They have to have that in there. So yeah, good job. I know it's kind of funny. You would think that the attorneys would understand that and know that, but it doesn't shock me. All right. So Form 22J applies to purchase and sale agreements. Form 22J lease should be used for lease rental agreements for housing built before 1978. I did hear of a broker getting in trouble. I don't know how far it went, but they did not include, they did a lease for a friend. Oh, I'll do it for you guys, for cheap, $100, $150, whatever. Put it in the MLS, help you rent out your house. They found, a renter pretty quick. They went ahead and filled in the, all the information. Leased it. The house was built in the 50s. All of a sudden, they had issues with the tenant, and the tenant filed a claim and said that, hey, we never got any lead disclosures for this property. And they've been living in the house, they had sick kids, and they basically went after the broker, the firm, the seller. $150. Yeah, so if you're ever dealing with a lease and you know that that property that's being leased, please, the same rules apply. It's a federal disclosure. It's got to be in there. You've got to use that 22J lease addendum. So even if you see one of the ones that you're helping someone on, on the MLS with, so be very careful about that stuff, because it could seriously cost you, it could seriously cost you a lawsuit or your license, or I don't know. I mean, it's a federal thing. All right, summary of regulations, disclosure requirements. In a nutshell, the regulations will require most sellers of pre-1978 housing to provide prospective buyers with the EPA approved pamphlet, protect your family from lead in your home regarding lead hazards. 2, specific lead warning statement describing the health implications of lead exposure. 3, disclose the presence of any lead-based paint on the property or advise that seller has no knowledge of its presence. List and provide all records and reports related to the presence of lead-based paint on the property. Provide buyers a 10-day contingency period to perform a lead-based paint inspection. So this is definitely one we're going to talk about. And 6, obtain an acknowledgement from the buyer that the pamphlet, disclosure statement, and records have been received. And if the broker involved, there must be a statement that the broker has informed the owner of his/her obligations and that the broker is aware of his/her duty to ensure compliance with the regulations. This includes anyone receiving compensation directly or indirectly from seller. So in most cases, the buyer broker should sign the certification along with the listing broker. So let's go look at a couple things. So first of all, what is the default for the inspection contingency on the Form 35? It's 10. That's kind of strange that these days kind of line up. That's weird. How long, like right now with our inventory levels in the market, what are you seeing for inspections?
3 to 5 days.
Or waived. So in the manual itself, it says that we're supposed to provide buyers a 10-day contingency period to perform lead-based paint inspection on any house that's built in 1977 and under. So can you see some dangers right away from, from selling a house that's built in those years? It's kind of funny to me that, that the attorneys never said anything else different on, here's the lead inspection timeline. Well, let's look at that. Let's go over to the Form 35. Because it does have and let's see, what does it say in here about lead? Nothing. That's weird. So there's nothing in there at all that says anything about that. What do you guys do when you go up to a house and the paint is curling on the outside. It's peeling all around the whole house. What do you say to a client when they're like, oh, we love this house and we would love to live here? Do you guys say anything about that when you recognize that paint that's doing that? What do you say?
Depends on the loan type.
And yeah, depends on the loan type. That's for sure.
It's FHA, you're gonna have to do something about it. There's no deal.
Well, even if it's conventional, they could call it,
Mhm.
especially if it's built prior, to 1978. VA will
and
absolutely
FHA,
call
yeah.
it. FHA will absolutely call it.
Yeah.
When you see that curling paint, that's like every chip all over, it's just like doing this curly. That could be a sign that, it could be, old paint, or it could be close to the layers of lead. So they will call it and they'll ask for testing. I've seen one last year. I didn't see one yet. I don't know if this is real wood. I haven't seen one yet this year, but it gets called. Cause no bank, no appraiser, they don't wanna see any lawsuits for this, especially when they know that, oh, in our inspection contingencies, there's no lead inspection. There's no timeline for that.
So let me get this straight. So someone puts 0 days for their inspection, so they waive their inspection. However, they didn't put 10 in there, they just left it as default to 10. They could get out of the deal if they decided to get a lead-based paint test and it comes back, because it will come back positive, right?
Well, there's a good chance. So let's talk about that. So how do you know there's lead? How do you know there's lead on lead-based paint in a house and it's built in 1950? How do you know?
100%.
I don't know. No,
You don't know?
It's just been layered on.
100%.
Like, you
Don't know.
just have the conversation of like, look, we can do this, but it's gonna open up a can of worms.
has to be tested
Right.
by that person that is authorized to tell you.
So, I mean, Jason's really right. I mean, if realistically, it was banned in that year. They started talking about it, before that and telling everyone that, hey, we're probably gonna be banning this stuff. It's gonna be a federal ban. It's not like it wasn't just one state. I mean, it took a while for that whole ban to happen. I don't really know the entire timeline, but that was the manufacturing. I mean, that is it. That's how paint was made. It's there. It's really a question of how many layers is it? How many layers of paint have been painted over it, right? We don't really know. If you went to go test, you could still find it today. It all depends on where they test. There's kits you can even buy at Home Depot. It's like a self-brand kit, you can scratch the paint, rub the thing, dip it, mix the solutions, put it in the little bottle, shake it up, and it'll give you like a quick kind of thing. Now, should you guys be bringing some kits with you?
No.
Why not? You want to help your clients, right? You're the best helper there is. No, don't do that. I heard some broker touting oh, don't worry about this. I'll be bringing my own testing kit and we'll be doing that for you. No, you will not. You will never do any inspections for a client ever, or work orders. No way. So really, when you're having the conversation with clients, I mean, honestly, if it's built in 1977 and under, it's there. It's just how many layers of paint have been painted over it through the many, many years. Okay, so obtain an acknowledgement from the buyer that the pamphlet disclosure statement and records have been received. And if broker is involved, well, we already did that one, didn't we? Okay, time limit disclosures. Jason, you want to hit G?
Sure. The disclosures must be given before the buyer becomes obligated under a purchase and sale agreement. If seller's disclosures are given after mutual acceptance, then the buyer must be given an opportunity to amend the offer as a practical matter. This means that because buyers typically write the initial offer and most buyers will not know whether the property has lead-based paint problem, and may not even know if the house was built before 1978, buyer will not be able to include a disclosure as part of their offer.
Oh, actually, you read to here and then we'll just keep going around the room.
Right.
Hayden can
Then
come
when
next.
seller responds to the offer and attaches the disclosure statement, the buyer must be given an opportunity to amend the offer, i.e. to make the counter offer. This could lead to an counter offer situation in almost every transaction involving pre-1978 housing.
Hey,
Seller can fill out Form 22J and attach the form as a supplemental to the listing. When the buyer writes the offer, the buyer can use the Form 22J that was previously filled out by the seller. In addition, the seller disclosure statement, Form 17, includes the lead-based payment disclosures required by these regulations. Now, if the buyer obtains Form 17 before making the offer, the buyer can check the appropriate seller's disclosure box on Form 22J in the same manner that the seller did on Form 17. When the seller responds to the buyer's offer, the seller can confirm the lead-based payment disclosures by simply signing Form 22J.
yeah, so like it's saying, you can look to see what the seller did on Form 17 and we can mark it, if they said yes, if they said no. But if there's no Form 17, there's no disclosure, then you're just gonna have to wait for the counter. I mean, it's just honestly a lazy listing broker that did not do their job to make sure it's in there. Okay, let's see, Karen, continue.
Note that even though seller may have made the lead-based paint disclosures in Form 17, the disclosure Form 22J still must be attached to the purchase and sale agreement, because buyer, one, still has to receive the lead warning statement, and two, must be given an opportunity to perform an inspection. Also, the broker still have to acknowledge their responsibility to ensure compliance. In short, we must use Form 22J and provide the EPA pamphlet in transactions involving pre-1978 housing.
Yeah, so just like we had, conversations about those types of, examples that you got to make sure it's there. You can't skip it. You just don't want to be in the situation where all of a sudden you can't get the other party to fill it out later, and then the next thing you know, you've got a deal they got mutual on and you got no federal disclosure form in there, that's in the transaction. So you just kind of have to, take over the transaction basically and tell the listing broker like, sorry, we got to have this in there, or vice versa. If you're the, listing broker and the buyer broker didn't include it, like it's got to happen. All right, records to be maintained. Mariah, want to do the next few?
Sellers and brokers must retain the disclosures and the buyer's acknowledgement for at least 3 years after closing. Penalties. The failure to comply with the regulations will not void the contract, though the buyer will have a right to amend the offer. A buyer who does not receive the disclosures can seek civil remedies, including triple damages, attorney's fees, and costs. Further, knowing violations can lead to heavy civil fines and even criminal penalties.
Yeah, it's like no joke. Triple damages. I mean, can you imagine like having that issue? That, and I'm gonna have to check with our in-house attorney, ask Aaron and see what does our E&O insurance cover? I'm thinking if a federal form is not included and everyone should know the rules. I mean, even when you're a new broker, part of the testing, they talk about lead-based paint, don't they? Yeah, it's like in the I mean, it's one of those things like, you got to make sure you understand this. So these instructions are just a summary of the regulations. These instructions merely provide an overview of the key points of the regulations. All brokers should be sure to familiarize themselves with the regulations requirement, since you are charged with ensuring compliance with them. All right, so filling in the blanks, date of the agreement, buyer's name, seller's name, property's name. So number 5, disclosure, presence of lead-based paint. Seller should check the appropriate box disclosing that seller has actual knowledge that lead-based paint or lead-based paint hazards are present, or alternatively, that seller has no actual knowledge of them. Note that seller is not required to do any testing to determine if there is lead-based paint on the property. Seller simply discloses whether or not seller knows that there is lead-based paint or lead-based paint hazard. Example, exposed, chipping, or peeling lead-based paint that could be ingested by children. If seller checks the box indicating that he or she has knowledge of lead-based paint, then seller should explain the nature and the location of the lead-based paint and or lead-based paint hazard on the blank lines provided. So that is where the spot for, for the seller right here is, right here, does present lead-based paint. So if the seller actually has known lead-based paint and or lead-based paint hazards are present in the house, then they have to make that disclosure. Sorry about that, guys. So this is the spot. I mean, realistically, if you have conversations about, has the seller ever done testing? Have they done that? Or if it's actually been found, in the property, then it's gotta be filled in here. That is one of those things, like, just keep in your mind, triple damages. You don't want the client, like, has anyone ever gotten one of these and seen it marked and filled in and it said known or seller has records even?
I had a guy who was an engineer for a city of Kent.
Uh-huh.
He said, yes, and he put whole house. And
Oh,
I was like, yeah.
Yeah.
Yes.
what, if you saw that and the buyer saw that and you're having them sign, like, what do you guys say? What's that conversation look like?
Prior to, that base was in all.
Yeah. Now you've got to remember that this is actual knowledge, that this is them knowing that it's there. You know how we explain it to buyers that if it's in 1977 and under, it's there, just a question of how many layers of paint's over it, right? That doesn't mean in the future, when the same buyer goes to sell it and you're listening again, go, oh, it is in here, right? You told me it's there, just how many layers? Are you gonna have them actually mark that? What do you think, Karen?
Oh, let's get to something else as soon as you're done.
Oh,
Sorry.
what about you, Zoom people? You're awfully quiet today. What will you tell the client then in that situation? Because it says actual knowledge. Remember, that's what we read in the instructions.
If it's actual knowledge, would that mean that they know exactly where it is?
Yeah, that means they know where it is. Yeah, it's only actual knowledge. It's not like we've explained to buyers that, hey, I mean, obviously it's built in 1920. That's how paint was made. Obviously that's exactly what was in the production, right? I mean, of paint, like that's just, it's probably there. We just don't know, right? That doesn't really mean actual knowledge. Actual knowledge is they've tested it or they found it and they basically either painted over it, they did something, but they actually found out, have knowledge. So just make sure clients are properly disclosing.
So should we, like you were saying, a lot of times I just fill it in myself.
Yeah,
Should we send this with the Form 17, like kind of stacked on top with it open so that they,
you can.
yeah.
You can, but I think I mean, realistically, you should have the conversation. Just have the conversation. Now, have you done any lead-based paint testing? Oh, no, we haven't. Why? Should we have? No, you shouldn't. I don't know. It's just, we gotta, gotta ask. So then I know how to properly fill this in. Yeah. Karen, you had a question?
Yeah, can you scroll back to where you were?
Go back to the form.
So the wording says no lead-based paint and or lead-based paint hazards are present in the housing. So, but if it's on the house.
Yeah, it's
Yeah,
it's
should be
both.
reworded.
Yeah, the wording is a little weird. It's in the home at all, but it's outside the house paint. It's the house. I think the last one I really saw was that original garage. And it was in bad shape. That they knew it had lead-based paint and they actually filled it in that way. So that's the last one I recall even seeing. It's been a while.
Yeah, I just had a VA, I was the listing broker and the VA was for the buyer.
Mhm.
And the garage, they made the whole bottom of the garage be like sanded and repainted, that was part of the inspection.
Yeah,
Or
yeah,
the,
appraisal. Yeah. VA will, I mean, they're very strict on it. FHA pretty strict.
I had the peeling paint on a shed door.
Yeah, and they call it, huh?
They called it, yeah,
Wow.
on the shed. I was like, okay.
Yep, all right, so there's seller's knowledge on that one. Let's go to 6. Let's see. Pick out somebody. Davis, want to read number 6?
Yes, reports and records. Seller also must list all records and reports relating to the presence of lead-based paint on the property that are available to, reasonably attainable by the seller at the time of the disclosure, and must provide copies to the prospective buyer. In multi-family properties, this includes reports on the paint histories of units in the target housing, other than the particular unit for sale or lease. HUD and EPA have indicated that this requirement does not include medical histories or reports on previous occupants of the target housing. Sellers should check the appropriate box indicating whether seller has any such reports and confirming that they have been provided to the buyer.
Okay, so if they've got any reports, like I have seen properties where they had to do the full, like, because they tested it, they found it, and then the seller's like, oh my goodness, now we gotta remedy it. And it's expensive. They gotta come out and wear full hazmat suits. They lay down giant plastic and protection, like things to catch all of the paint chips and everything. This is on the outside of the home that this property had it, and they literally had to, they had to use like a sandblast. I don't know if they did a sandblaster or something. They did something that it wasn't like pressure washed, and then they had to wire scrape it, and then they had to coat it with a chemical. Then they had to take all of the actual plastic stuff and wrap it all up and put it into these giant like containers. And then they had to go take it to a place to properly dispose it, but it was expensive. I want to say it, like, how much does it normally cost to paint an outside of the house? Like probably like 5-6 grand at least. I want to say, huh?
5K minimum.
Yeah,
Like,
yeah, you're pretty much,
That's a ramp for,
yeah.
might have to have theirs completely repainted.
This was like 20 something thousand,
Oh, yeah.
like 28 grand or 25,000. So it was really expensive because the cost of not just, doing the normal work, they go above and beyond that. They had to totally like scrape the crap out of it, and they got to pay for the disposal of the lead paint chips. And it's like the whole process of the way that they like tuck this protect, or it's like plastic with like this thick little, I don't know, like a hook thing that they shove underneath the siding on the base all the way around it. And then to make sure no holes are, behind there so that everything they scrape is falling into this like catch thing. Yeah, it's crazy.
Sounds like asbestos.
Yeah, it's almost that bad. It literally, have you guys seen the asbestos ones too? Yeah, it's the same type of thing.
So if you have that report, would you stack that on top of your Form 17?
Absolutely. If you had that done on the house, then you get the reports and then they basically, yeah, that would go with it. You would absolutely make sure that the seller, provided that. So when you're questioning the seller and, about say, since it is built prior to, to 78, then I would just ask them, did they ever do any testing? And if they did any remediation of lead? Then if they say yes, you're like, right away, red flag should go up like, okay, great. We need to make sure, do you have the reports? What was done? You definitely need to like investigate further, ask questions, and also make sure that the seller properly discloses that in the seller disclosure statement. So many people think that, oh, since this happened and it's no longer an issue, I don't need to disclose it. That's what a lot of people think when it comes to any of the disclosures. But really what's best is, no, there was an issue. It's been remedied. This is who did the remedy, and here is the proper paperwork and the documentation that goes along with it. What is going to make a buyer feel much better about, any of those disclosures that said yes or no, like, yes, has the roof leaked in the last 5 years? Yes. And then nothing else is said. What is that going to make them feel like? Yeah, maybe it's never been repaired still and it's still leaking, so it's one of those things that if the documentation's there, provide it, make it a part of that disclosure and make sure that the seller writes it in, and properly discloses this. So then it's not an issue. So of course, seller's got to sign and date. Seller must execute the lead-based paint disclosure in the space provided. Initials, buyers and sellers should initial the spaces. Next will be the buyer's acknowledgement. So buyer must initial to confirm that buyer has received the seller disclosures information as marked on the first page of Form 22J, including explanations and documents, if any, and also initial to confirm receipt of the pamphlet, Protect Your Family from Lead in Your Home. Buyer's opportunity to inspect. So what happens if you're the listing broker and on the 22J itself, you see that the offer comes over and there are missing initials in line 33. What do you do? Do you worry about it?
That's the pamphlet being disclosed. Yeah, I guess.
This is one of those things where I would probably say, if you're representing the seller, get your mutual. That's on the buyer broker. I mean, realistically, I would not turn away a deal and not get mutual as long as this is here, everything else is properly done except for these boxes. That's really on the buyer broker. You don't really need to go, into that, I guess, for it. If it's been provided, the disclosures are all there in the Form 17 and they line up for your seller, I wouldn't if you're going to counter anything else in the deal at all, you might as well then make sure it gets initialed. See the difference? Like you might as well, like at that point, oh my God, we're going to counter the price anyway. Okay, go ahead and say, hey, can you also make sure your buyer initials and, or ask the buyer broker, hey, did you give the buyer the pamphlet? And they're like, what pamphlet? Then you know that, okay, you better make sure you give it to them. And then also, can you please have them initial on line 33, page 2 on the 22J. So That's how you should handle that type of situation. All right, section 10. Let's see. Oh, Vitali, actually, I can get you. You want to read that one?
Buyer's opportunity to inspect. Check whether buyer accepts or waives the opportunity to conduct a listing or inspection of the property for lead-based paint and or lead-based paint hazards. Buyer must be offered a 10-day inspection period, which can be waived, lengthened, or shortened, or otherwise modified according to the parties' agreement. No, the inspection procedures in the form are similar to the inspection addendum. Form 35, buyer must get an inspection, and if any adverse conditions are identified, buyer must advise seller of the nature of the conditions, and unlike the inspection addendum, give the seller a copy of the inspection report. Seller can then decide whether to repair the conditions. If seller will not repair them, then buyer can terminate the agreement or purchase the property without the repairs having been accomplished by the seller.
Okay, so we got a unique thing here, don't we? House is built in 1920. Home inspection form 35 has been waived. But on the 22J, buyer's going to go ahead and mark the accept an opportunity, conduct a risk assessment or inspection of the presence of lead-based paint and or lead-based paint hazards on the following terms and conditions. This agreement is conditioned upon a risk assessment or inspection of the property for the presence of lead-based paint and or lead-based paint hazards to be performed by a risk assessor or inspector at buyer's expense. This contingency shall conclusively be deemed satisfied or waived unless buyer gives written notice of disapproval of the risk assessment or inspection to seller within 10 days after receiving the disclosure. Buyer's notice must identify the specific existing deficiencies and corrections needed and must include a copy of the inspection or risk assessment report. Now, the buyer's got to hire somebody, correct? Now, the buyer can pick a home inspector. Now, does that mean the home inspector can now inspect the crawl space, the attic, the roof, the electrical, the plumbing, the fixtures? What do you guys think?
Technically, no, but.
They will.
Too.
Yeah.
What, how, well, wait a minute. Are they allowed to inspect the full property like a normal inspection?
Not supposed to, but I can see it happen.
Just looking to see if there's any lead-based paint in the crawl space.
Yeah.
It could be down there. Checking it out.
Might be, probably supposed.
So this is a situation where, we've seen some people try to do like wiggle and use this as an excuse to still have a full inspection. But if they do not actually go and test for lead only, like that is the only out that they would get. You would have to have that full lead, test report. Honestly, if you're representing a buyer and they're going to do this, you got to make sure that they are an actual person who's going to do the full lead inspection only. Don't try to go and actually do a full home inspection, testing the plumbing and all, like that is not what the inspection is supposed to be doing.
Well, it's different. This one, it says that you have to give them the inspection.
Yeah.
You can't give them the inspection for your inspection or you're waiving.
Yeah.
inspection.
Yeah.
So it's interesting how it's different.
It is different. So you are the listing broker. On the flip side, maybe the buyer did waive inspection 35W, and then they've got this and they're going to say, yeah, they're going to accept to do this. I guess you better make sure that's exactly what they're there to do. But it's one of those things like you're going to have to talk to the seller and say, this is one of those things that it could be seriously a danger kind of a situation, because what if they do hire someone, and what if they find lead? And they give you the report, and then they bounce. They're like, we're out. Good luck with your house.
You have to update your Form 17.
And your lead-based paint.
And if you have that, report, you're gonna have to put it in your supplements, right?
Yeah, but what will that do to a seller? You think that's gonna affect their sale into the future?
Yeah, drop it by at least the cost to fix it, right?
I don't know. Yeah, who knows? Or you might not even get a buyer. You might get another buyer and they're gonna go, oh, it's got lead in it? We got a newborn baby on the way and we already have a 3-year-old? No way. We're not buying this house. It could seriously cost the sale. It could cost the future sale. Or it's gonna cost them a lot of money because now they're probably gonna have to take care of it. Well, it's to actually probably doing the full remediation, the lead remediation process, and it's gonna be expensive. It's something that probably the seller did not anticipate.
How often have you seen people actually do the lead case?
It's rare.
Yeah,
It's rare. I mean, you're looking at so many years, like 50-something years, since that's been banned. There's definitely many layers of paint on top of it.
how much would that inspection cost? Because then you have to do a special.
No, you know what? The specialist, it's definitely more expensive. Oh, it is definitely more. Yeah, it's probably gonna cost them about $1,000, I'm guessing. For a buyer.
What
Perfect
stops
out,
them
and
from
then
getting
yeah,
an April
spend
one
$1,000.
inspection, like you being there present while they're getting their lead-based paint inspection, or? I mean, cause this is.
Yeah.
In a way, it's a loophole, I mean, with
Yeah.
multiple offer situations, it
Especially
is definitely like today,
Could be.
you know?
I mean, is that something you're gonna tell? I would definitely be careful to tell the buyer that, hey, you're gonna have your lead-based paint inspection, have your inspector do the whole house. I don't know if I would say that because you're gonna be getting, technically that's putting them in breach of the agreement. The inspector, who they're supposed to hire, is a professional, as an assessment of, and, someone who's actually gonna do the full report of lead, testing. That's what they're supposed to be doing. I'd be really careful and mindful about conversations with the buyer about that. Because as soon as you do that, and the listing broker's like, well, I'm gonna be here for it. And that inspector's not even testing it, and he's doing an inspection, he's gonna do, this broker go, okay. Time out,
That's what I meant.
what's going on?
Seller, yeah, like,
Yeah,
you
just
just
go.
show up to it, like.
Yeah, you might want to.
Now there's 10, 20, 30 offers. Inspections. Should say hypothetically, they come in with a lead-based paint inspection,
Yeah,
but you have a feeling they might be inspecting the whole place too while they're out.
Yeah.
So it's like you show up, and be there for it.
yeah, there's a lot of people that in the event you're actually waiving inspection, as soon as you hear the buyer broker's like, hey, is it okay if we go this weekend? We're gonna go for a couple hours and maybe like measure and
Take measurements.
red flag, like, no. When's the buyer allowed back into a property if they've waived inspection? What?
Final one.
Final walkthrough.
Yeah, the final walkthrough is the only time they're supposed to be back in that property, 5 days prior to closing. Yeah, was that last year or the year before? We had one of our listings, one of our listing brokers was like, what the hell's going on? They're accessing the lockbox. Like 8 days after, 5 days after the mutual. So they call up the buyer broker, hey, what's going on? Oh, yeah, the buyer wanted to go ahead and just have it inspected anyway. What? You're not even allowed to be in the property. Get out of the seller's home. You have no permission to be there. And then all of a sudden they're like, oh, buyer wants to get out of the deal, they, you know, something like, well, did, you know, here come to find out the buyer broker said, oh, it'll be okay, you can still have it inspected. Is what the buyer told the listing broker, because they showed up. The listing broker had to go to the property right away. Yeah.
So I had like a, kind of an idea,
Mhm.
kind of devil's advocate type thing. So someone waives inspection, someone waives all this stuff. And then they decide they want to get out of the transaction within 10 days, they could go hire $1,000 person to do an inspection on it. More than likely, it'll come back as positive.
They could maybe find it.
And get their $20,000 earnest money back.
Maybe, but you better, don't forget that this better be marked, that it's accept.
Yeah.
You know, you gotta be accepted to do it, and then you better have the time. And don't forget, you're gonna be, you gotta get it to be a report from that specialist too, so. It's definitely a thing that's, you know. You could
Yeah.
do it that way. Okay, buyer, we did that. It's got to be there. Gives the buyer an out. 11's time limit, buyer's disapproval, insert the number of days that buyer has to, given written notice of disapproval of the inspection report. If this notice not timely given, the inspection contingency is waived and buyer will have to purchase the property without seller correcting the conditions. Buyer's notice must specifically identify the conditions to which buyer objects and also must include a copy of portions of the report that contains the condition to which buyer objects. So you're getting it done with the expert, you're supplying a report only of the pages of which the buyer's objection. If the buyer's objecting to the whole entire house, you got to give the whole report, and you're asking the seller to remedy the whole paint. So that's going to be expensive, big time. Number 12, time limit seller's notice. Insert the number of days seller has after buyer's disapproval notice to give notice that seller will repair the conditions identified in buyer's notice. And then time limit buyer's second notice. If seller does not give notice that seller will repair the conditions identified in buyer's notice, buyer can elect to terminate the purchase and sale agreement within the number of days filled in here. If buyer fails to give termination notice within this time limit, buyer will have to proceed with the purchase without the repairs being made. Sign it, date it. Brokers have duties under federal law to ensure seller complies with the lead-based paint disclosure requirements. Buyer broker must execute Form 22J in space provided. Listing broker signature and date. Brokers have duties under federal law to ensure that seller complies with the lead-based paint disclosure requirements, and listing broker must execute Form 22J in space provided. And then, of course, buyer and seller initials. So there is the whole form. Don't forget that. Don't leave the blanks, please. You know, fill these in. I think if you're going to do lead-based paint inspection, I don't think you should have anything shorter than probably a week. Because don't forget, if you're having that done, that's testing, that's lab testing. They got to send it out. It's not just for the actual inspection process to be done. There's a whole behind the scenes process that's got to happen. You better have over a week. I would say 7 to 10 days, you know, at least. And then you got to find that expert. If the buyer wants to have this done, do you guys have someone who can do this in your back pocket right now? That might be something you might want to start finding out on who an expert is. So you've got that ready, you know, in your team, you know, like we always say your professional service providers, you might want to have that. That's something that, you know, maybe some of your sellers may need in the future, or buyers.
Your inspectors that we usually use, do they usually have someone that they?
Yeah, that's the first person I would go to. Go to your inspectors right now. Say, do you do lead-based paint testing? Do you have the professional? Can you handle the professional process to be able to give a full inspection for this? You know, yeah, some of them do.
Is that a different license? Do they have to have?
It might be. Yeah, it might be. Might be some kind of rider or something to their license to be able to do that. All right, you guys, that is forms class for today. Thank you so much for making it. We will see you guys on the next one.